Welcome to Sakshi TV's special immigration show with attorney Ms. Prashanthi Reddy from the Law Offices of Prashanthi Reddy, PLLC. Please note that Sakshi TV now has 3 immigration shows every week on Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with attorney Prashanthi Reddy in English, and on Friday at 6 p.m. EST with attorney Bhanu Ilindra. Please tune in to ask your questions. If you're an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Prashanthi reads no introduction, but if you need consultation, please log on to reddyesq.com for contact information. When you connect with them, don't forget to mention Sakshi TV. From the beginning, the reddyesq.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The reddyesq.com site provides you with latest and cutting-edge information on US immigration law and policies explained in terms you don't have to be a lawyer to understand. Today's topic is the Budget Reconciliation Bill, alternatives to H1B. We will continue the knowledge session along with the news and updates on latest immigration, followed by Q&A. Before we get into the topic, you can call us on the numbers displayed on the screen for questions related to immigration and also ask for tips. Hello, Ms. Reddy. How are you doing?
I'm good, Tony. How are you?
Very well, thank you. So, Ms. Reddy, before we get into the topic, are there any immigration updates that you'd want to share with our viewers?
Yes, we are going to do that shortly.
Right. So, would you like to get started with the immigration updates then?
Yes.
Right.
So the first update is I wanted to give you an update on the Budget Reconciliation Bill. And now for those of you who don't know it, it's extremely important news, because if it gets passed, then it has widespread repercussions for legal as well as illegal aliens, legal immigration as well as those who are aliens who are not in status. And this is our best chance for some kind of immigration reform to pass. And this has been the legislature has been trying to do this for the past 10 plus years and not successful in doing so because of all the politics that goes on, and because one party not having majority in both houses, so in the House and the Senate. So now Democrats have the opportunity to do it, but there's still challenges. So at this moment, what's happening is they've introduced some immigration legislation in the budget bill, and it was passed by the Senate and the House, but the immigration provisions in the Senate and the House are different. So now something called budget reconciliation has to go through. So the parliamentarian does that, and the parliamentarian's office will go through both versions, and so then the Republicans will separately look at the House bill and see what changes they make. The House members will look at again the bill, the bill version of the Senate, whatever the Senate changes are with reference to immigration. That's what we're concerned about in this program. And once that's done, then the House can just pass the bill with a simple majority. They don't need 2/3 majority. It's just a simple majority, and then it will go to the president for signature. So there's a good opportunity for some real immigration reform here. So I thought we have to definitely mention that in this program that we have. And we're expecting, this is time bound, so we're expecting this to happen in this month and then get passed next month. So let's see what happens. This is yet another opportunity for immigration reform, as I said. So just going through a summary of what immigration changes have been proposed. One is allowing certain people to apply for legalization. So that includes both documented as well as undocumented people. So people who are illegal, that is, people who don't have any status in this country, as well as people who have status. They may apply for adjustment of status after paying, that is a 485 adjustment of status, after paying a fee of $1,500 and a completion of a background check and a medical exam as well. That category of people who will be eligible to do that are dreamers. Apply for legalization, that is, are dreamers. Dreamers are those people who are here at the age of 18, went to high school here, etc., etc. So all those young people who came here as when they were young and were fell out of status because of no fault of their own. Essential workers. So essential workers would be defined to include farm workers as well, and essential workers would be hospital, I presume healthcare workers, people who are helping with COVID. So there's a definition. DHS has a definition for essential workers, so they will follow that definition. TPS, people who have been given temporary protected status in different countries at different times, depending on the situation in their country. The people who are here are given temporary protected status, which will allow them to remain here and not have to go back to their country. So such people are also granted EAD. So such people will be allowed to legalize. And those recipients of deferred enforcement departure. So all those people who are out of status, but USCIS has decided that they're not a priority for deportation or removal. And there's again various factors to decide whether they're a priority for removal or not. It could be age, it could be, also if they have any criminal background. So, those are two of the main criteria that I looked at. So those people, deferred DED people, deferred enforcement departure people, are also considered under this category and can legalize by paying the $1,500. Now this will be effective. So each category has different eligibility requirements and physical presence requirements. And there are also many inadmissibility grounds that apply to legalization. So there may be many instances in which they may not be able to apply. But there may be a waiver for those inadmissibility grounds based on humanitarian concerns, family unity, public interest, etc., etc. The effective date of this, if it happens, remember this is just a proposal and we're hoping that it'll happen, but it hasn't yet. But the effective date, once it gets approved, is 180 days after the enactment, or May 1st of next year, whichever is earlier. So let's see what happens. The second provision is in this immigration reconciliation bill is the recapture of unused immigrant visa numbers. As you all know, we have a huge problem with Indian nationals and Chinese nationals because their employment-based and family-based visa numbers are backlogged. So there's a wait sometimes for 10 plus years for people to get their green card, especially if you're an Indian national. And every year a certain number of visas are opened up, but those visas don't get used because USCIS is not able to process them and use them. So those visas then remain unused and they are not moved to the next year. So that's a huge problem. So in order to kind of temporarily fix that problem, they have proposed, the House has proposed that USCIS be able to recapture all those unused visa numbers, both employment-based and family-based, since 1992. So that will be a huge dump of available visas into the general pool, and definitely will be helpful for those that are backlogged.
Right.
Avoid double counting of visas. So often each family member is given a visa number, and thereby visa numbers are wasted. So we're hoping that will stop. Also for diversity visas, which is a different category of visas, based on diversity, and only certain countries can apply. So preserve the DV visas not issued since 2017
Right.
due to all the bans due to COVID. Do we have any callers or can I continue?
Yeah, please continue.
Okay. Then the next one and most important one for legal immigrants is adjustment of status. So allowing certain people who are here legally to apply for a 485. So allows for filing of adjustment of status for family-based as well as employment-based applicants upon the approval of their I-130 if it's family-based or I-140 immigrant visa petition if it's employment-based. And it does not require a visa number to be immediately available. If you pay $1,500 for the main applicant and $250 for each derivative beneficiary, you should be able to file. So the basis on which you can file this is as follows. It's only applicable until September 30th, 2031. So they've given it a 10-year window. And it creates an exemption from the per country limit. So as we just discussed, there's a limited visa number availability every year. And again, every country has a limited visa number availability. So it kind of removes that per country family-based as well as employment-based numerical limitations. If their priority dates are 2 years before the date of, meaning if their priority dates is not going to become current for another 2 years, so that it's 2 years out, then they don't have to wait for their priority date to become current. So 2 years or more. If it's less than 2 years, then they have to wait. But if it's 2 years or more, wait for their visa number to become available, then they can apply for adjustment of status. And again, there's a fee for this, $2,500, which is huge, but I think worth it because most people can afford it. So if they're getting a green card, so $2,500 fee for all these AOS applicants. And there is a for family-based, it's $2,500. For employment-based, the fee is actually $5,000 for all EB1, EB2, and EB3 categories. And then for EB5, which is the investor visa, it's actually $50,000 is the fee. So I hope that's clear to all those people. Allows for filing of AOS for a period of for a supplement fee of $1,500 and creates an exemption from all per country cap situations for people if they as long as they pay that extra fee. So definitely very, very helpful. It will remove backlogs on all these employment based and family based categories. So let's see what happens. And then also they're also establishing an additional fee for which is not that much, but for all immigrant visa petitions, $100 fee for employment for family based and $800 for employment based. This is when you're filing the I-140. And they want all that money to go into the Treasury fund. So this is, since it's a budget reconciliation bill, they are providing these additional fees so that the parliamentarian, I'm presuming, doesn't have objection, because they cannot put in any new requirements which have an impact on the budget. So as long as they follow that criteria, they will be able to add these immigration provisions. So I think that's the purpose of adding all these fees. So an additional $2.8 billion dollars will be given in the budget to USCIS for backlog and taking care of asylum cases, etc. And then, so these are some of the things. We can go into details. Also, there are further details to go into, and we can go into those details very quickly. So for the eligible categories, I already told you who the eligible categories are. The essential workers, the additional requirement is that they should be physically present before January 1, 2021. There are several, as I said, grounds for ineligibility. Recapturing of unused visa numbers we already discussed.
Right.
All those numbers which were not used since 1992 will again be used. Adjustment of status, people who can file their adjustment of status by paying a $1,500 fee.
The Biden
And
administration has,
then,
yeah, right.
yes,
I was just saying that the Biden administration has actually come up with quite few effective solutions. So here's hoping that things go forward.
yes, let's hope. I mean, we can discuss it as much as we want and go into all the details, but I think it's best to wait until something happens and then discuss more details. I think so far whatever we've discussed is sufficient.
Right.
And we can move on to the next topic, which is basically implementation of COVID-19
Vaccination requirement.
vaccination. Yes. So, in order to file your 485, as you all know, those of you who have filed, or you may have heard from your friends that you need to do a medical test and take certain vaccinations. So those vaccinations are that were previously included were, mumps, measles, polio. You have to make sure you get your tetanus shots, your flu vaccine if you are filing during flu season, hepatitis A and B. So in addition to all that, they've also now included COVID-19 vaccine. So that's a very important addition to
Right.
your 485 So unless you're fully vaccinated,
So
you cannot get a green card. So we've seen that a lot of people are again getting a request for medicals because they want their medicals. USCIS wants their medicals to be updated with the COVID-19
right.
vaccine.
Ms. Reddy,
There is, yeah.
sorry to interrupt you, but with your due permission, we have a caller on hold. Mr. Bhanu from North Carolina. Thank you for calling, Bhanu. You may ask Ms. Reddy your question directly.
Hey, ma'am, how are you today?
I'm good, thanks.
Hey, I have a question. So, me and my wife both applied for EBT downgrade last year. And my wife already got EAD. So, it is like EB2 to EB3. Mine was still pending. So, can my wife use the EAD and can I be on the H1?
I cannot hear you, unfortunately.
Bhanu, could you please
Orni,
probably...
can you hear?
Yeah, right. Bhanu, could you please adjust your mic and your position, with respect to the mic? We're not able to quite hear you.
Okay.
There's some disturbance in your line. If you could please check that. There's some static. Could you try now, Bhanu? Bhanu, are you with us? Hi, Bhanu, are you with us? Looks like we lost Mr. Bhanu. I hope you call us back, Bhanu, for your question. Mr. Reddy will be available for a while now. Mr. Reddy, meanwhile, if you could please continue with the updates.
Right. Absolutely. So we were talking about the COVID-19
Vaccination
requirement.
Yeah.
And so there, even though it's a requirement, there are some waivers that are applicable, meaning there might be some situations in which you'll be forgiven even if you don't take the vaccine. That is, number one is if you're not required to based on your age. For example, the COVID-19 vaccine is not available for all ages. If you cannot be administered the vaccine because there's some kind of a medical contradiction, which means, for example, if you are pregnant then you're not supposed to take it. Or if you are allergic to the if you have allergies to the vaccine, then you may not be required to take it if you have a letter from your doctor. Also, if it's not time to take it, which means
Miss
say
Reddy?
you took the two. Yes.
So sorry to interrupt you again. We have another caller on hold, Mr. Rahul from Atlanta. Thank you for calling, Rahul. You may ask Ms. Reddy your question directly.
Thank you, Tarani. Hi, Ms. Prashanthi.
Hi.
Hi. I have a question related, two questions actually. One question is my EB, my firm is in EB2, so we applied EB3 in premium, so that is approved. So can I apply EB2 premium again right now with the same firm?
There is no premium for perm. You're talking about the I-140. You want to apply for the I-140.
Yeah, sorry.
Is that correct?
Yeah, 140.
Yes, you can apply for the I-140, but if you do not have the original labor, you cannot apply for premium processing.
Oh, okay.
If
So
you are eligible to apply for both EB2 as well as EB3, you can apply for either. You should apply it as a new I-140, not as an amendment if you want to keep both. But unfortunately, if you don't have the original labor with you, they will not accept your case in premium processing. They might, once you file it, you might be able to convert it. Sometimes they do that, but initially when you file it, you'll have to just file it in the regular processing.
Mine is EB3 premium processed in Nebraska. So the my 797 H1 also in Nebraska. So sure, Prashanthi, I will try that. Second question is we applied our 485 EB3 premium in October last week. So that that is final action date is current. My final action date is current 2013 December in October 2021, and my 140 is approved in November first week after retrogression. So my son age is locked or not? That's what I want to know.
Your son's age will be locked only after if he's under 21 when your final action date becomes current.
Yeah, he is 15 years old.
Yeah, so it's locked then.
Okay, so 140 is not
unless
approved
unless the 485 gets denied and you have to refile the 485, then you will not be able to use that opportunity. But if the 485 continues as is and it gets approved, yes, it's locked.
Yeah, 140 is approved after retrogression. That is fine, right?
I-140 doesn't have anything to do with it.
Okay. Thank
The
you.
only requirement is that
Thank
485 be filed and final action date be current. That's when it becomes locked, the age.
Okay. Thank you, Prashanthi. Thank you.
You're welcome.
Right. Thank you for calling, Rahul. So, Ms. Reddy, you were telling us about the vaccination requirements.
Right. So I was talking about the waivers. So as I said, if you are not required to take the vaccination at that time, because vaccinations are administered in a series in intervals. So if, for example, you took you have two vaccines, and the booster shot is not compulsory right now, so they will not require you to take the booster. Or you've taken one vaccine and it's not yet time for you to take the second one, then that counts as a waiver. You don't have to take the second one. Or if you are applying in the summer, then you do not need to take, like, for example, a seasonal vaccine such as the flu shot, because the flu shot is available only in the fall. So those are some of the exceptions for the COVID-19 vaccine. And of course, then they have vaccinations in general, actually. But of course, they have the blanket waiver also. So if there is a shortage of vaccines, any kind of vaccine in in the US, then automatically you're given a waiver and you don't have to take that particular vaccine.
Right. So, Ms. Reddy, with that, I think you've explained to us about the implementation of the vaccination, COVID-19 vaccination requirement. And so we are moving on to the other part of our topic, which is the alternatives to H1B. What would you like to tell our viewers
Yes.
about that?
Well, since the cap season is over, I mean, there was another, for the H1B, for those of you who are involved in it, there was another lottery, the third lottery recently, and some cases got picked, and then they have, you can file those cases by January, so the lottery is still going on. But obviously, if you were not picked if you did not register, or if you were not picked even in the third round, I doubt there'll be a fourth round. You will not be able to, file a H1 until, or at least you will not be able to come to the US on a H1 until October of next year. And you will have to register next year, March or April, and then file, and then the registration has to be picked, etc., etc. So it's important to understand if there are any alternatives to the H1. So one of the alternative is a cap-exempt H1. So filing a H1 that is not subject to the numerical cap limitations. A number of employers may qualify to be cap-exempt. A cap-exempt employer is an institution of higher education that is related or affiliated to a higher educational institution, non-profit entity, or a non-profit research organization. So not only do they have to be an institution of higher education, but they have to be related or affiliated to a higher education institution or a non-profit entity, or they can be a research organization. So all these organizations are cap-exempt. A cap-exempt, again, the cap-exempt organization doesn't have to be your actual employer. If you are an IT consulting company, the cap-exempt person can be the end client. The company can be the end client, doesn't have to be your direct employer. So that's a good thing, which we often disregard or forget about. So if your end client is a university, an institution of higher education, or is a non-profit research organization, right? So then, you will qualify for a cap-exempt petition. So something to keep in mind if your organization is cap-exempt.
Right.
Another option for cap-exempt, another option for a H1 is the O visa. The O visa is for people with extraordinary ability. Obviously, everyone doesn't qualify. It's extraordinary ability in the sciences or in the arts, or in education, in business, or in sports. So if you do qualify, remember it's definitely an option. And the good thing about the O non-immigrant petition is that it leads to EB1 category. So you can apply as EB1 green card category, and you can file a I-140 directly, and EB1 is presently current, so you can file a 485 as well if you qualify under that extraordinary ability category. For example, if you are a chef, you're a celebrated chef, or you have been featured in news articles and on TV, etc., etc. You have your own book. You may not qualify even, properly for a H1, but you'll definitely qualify for an O1. If you are an IT professional, but you have, actually created your own software, or created some kind of a methodology, and you have a patent on it, then you could be a person of extraordinary ability in the sciences. So, or if you're a researcher, same thing. You can possibly apply for no one instead of applying for a H1. The other option is, of course, the L1 category. The L1 category, again, The L1A especially is much sought after because the L1A category leads to, again, EB1. So a green card based on EB1, and EB1 is current right now. And there's no need to file a labor. You can directly file an I-140. So an L1 is for an intra-company transfer. So a person who, if there are two companies, one is a branch and one is a subsidiary, and say one is located in India and the other company is located in the US, the India company wants to send someone to the US company. That someone has to be an executive or a manager level. You cannot send anyone, but it's possible to send them. They can be owners of the company as well. So, for example, you have a project manager kind of situation. Instead of doing a H1, you can do an L1A. So an L1B is another option for people who have specialized knowledge in the process and product. Most MLCs prefer doing L1Bs to H1s. So that's definitely another option for in lieu of a H1. And the advantage of an L1 is there's no prevailing wage, so you can pay any wage that you want as long as it's a reasonable wage. There's no need to file for amendments each time. So definitely a lot of benefits. And the L2, the L1 dependent L2 is automatically allowed to work. They don't have to apply for an EAD. So that's another huge benefit for the L1, something to think about.
Right. So
should I continue, Thorny?
yeah, please.
So the other option is the TN. The TN visa is for people from Canada and Mexico. So if you're a citizen of Canada or Mexico, you can come into the US on this TN work visa. If you're in the IT profession, there are certain designated occupations. There's a list of designated occupations. If you fall within that list of designated occupations, you qualify for a TN visa. So, for example, I believe a systems engineer or an engineer is a designated occupation for an IT professional. So you can bring an IT professional under that designation, and the requirement is basically a bachelor's degree in computer science or engineering.
Right.
So the advantage of Canadian TN is you don't really have to apply anything at the US. You don't have to file a form like you would for a H1. They can directly take the documents, and all that is required is a letter from the employer talking about the job offer and how it qualifies for a TN. The potential employee's educational credentials. So you take that and go to the consulate. Not even the consulate, actually. You just go to the port of entry.
Right.
So you're at the airport, or if you're traveling by road, you go there and ask for the TN visa, and you're granted a visa then and there. So that's the advantage of the TN visa and TN Canada especially. For the TN Mexico, you have to actually apply for the I-129, but really it's much less stringent on the whole. The TN is much less stringent than the H1, and there is no cap requirement. So there's no a maximum number of visas that can run out at a certain period of time.
Right. So, Ms. Reddy.
Yes, go ahead.
So, Ms. Reddy, with that, we come to the end of the show. And thank you for the insightful information you've given all our viewers with such detail, eye for detail and attention to detail about everything that you've mentioned about the Biden updates, vaccination requirements, and the budget reconciliation bill. So, we hope to continue this topic again on the next week. It was a pleasure hosting you, Ms. Reddy.
Thanks for having me, Thorny.
Right. Thank you. You're watching Sakshi TV Live with me, Torini Makana. Thank you.